Your Honour, may it please the Court, my name is Nguyen, initials K, and I appear on behalf of the accused, Darren Selders. Mr. Selders has been charged with 9 counts of breaking and entering, to which my client pleads not guilty. Through the following submissions, the defence will seek the Court's discretion to exclude the Crown's evidence of Mr. Selders' confession when he was being driven to the police station and when he was being interviewed in the interview room. Your Honour, it is submitted that the Crown's evidence, whilst admissible, should be excluded on 2 grounds. Firstly, the evidence of Mr. Selders' confession to the police officers were obtained in contraventions of multiple statutory requirements, thus contravening public policy by not following standard police methods. Secondly, due to the substantial prejudicial weight of Mr. Selders' confession, which occurred because of gratuitous concurrence, and that the reception to admitting this evidence would be highly unfair to Mr. Selders. In dealing with the first ground, it is submitted that the evidence tendered to the Crown may be excluded from the trial consequent of the officers' failure to comply with their legal obligations pursuant to the Police Powers Responsibility Act, hereafter the PPRA. The first breach was in relation to Section 418, where it states that before a police officer starts questioning a person, they must inform them of their rights to speak to a friend, relative, or lawyer, and must delay questionings to allow this to happen. Prior to being questioned, Mr. Selders was not afforded this right, amounting to a clear breach by the officers under this section. There was no attempt by police officers to delay questioning of Mr. Selders to allow him to contact a friend, relative, or lawyer. Police officers also breached Section 421 of the PPRA by disregarding Mr. Selders' right as a child and questioning Mr. Selders before informing him of the right to talk to a support person of his choosing. Although law enforcement did not know Mr. Selders' exact age, it is reasonable that the officers should take reasonable steps to find out his age and then treat him with the rights that come with as a child. While Mr. Selders did receive Wendy as a support person before the interview at the police station, Mr. Selders did not choose Wendy as the support person. Mr. Selders was not given the opportunity to choose his own support person. Law enforcement did not follow the standard procedure of allowing Mr. Selders to talk to a support person chosen by him. Another breach of the PPRA is Section 420, where it states that before questioning an adult Torres Strait Islander, they should be informed of their rights to a representative of a legal aid community, or to let them know that they are in custody. Although Mr. Selders is not an adult, officers should have deduced that Mr. Selders is a Torres Strait Islander and provide the right to talk to a lawyer or legal aid representative. These breaches of procedure by law enforcement shows that the officers are blatantly disregarding their responsibilities and have obtained evidence with reckless disregard for the law and Mr. Selders' rights. The confessions was obtained involuntarily, and law enforcement did not show any interest in protecting individuals from unlawful and unfair treatment. Further, the court should not consider whether the confession is true, but rather focus on enforcing proper police practices. If the courts favour the desirability to bring Mr. Selders to justice and decide not to exclude the confessions on public policy grounds, the court should look at the probative value and exclude the evidence on the balance of prejudicial weight and cogency. Your Honour, this leads me to the second ground of the exclusion of evidence, the fairness discretion. The defence should seek to exclude the evidence by legislation through Section 130 of the Evidence Act, which provides evidence that is unfair should be excluded. The grounds for why the evidence are unfair is because the confessions of the burglary are highly relevant and prima facie would have high probative value. However, because Mr. Selders is part of a special class, namely being a Torres Strait Islander, the confession during the drive to the police station and the interview should be excluded from evidence. This is due to gratuitous concurrence, a result of Mr. Selders' cultural background. Mr. Selders agreed and obliged only because he wanted to show respect to a person in authority, convey cooperation, and avoid conflict with police officers, even if he did not understand the questions. Because of this, the actual probative value is quite low, and if not excluded, the probative force of the confession would sway the verdict with strong conviction and adversely affect Mr. Selder's right to a fair trial. In conclusion, both fairness and public policy dictated the confessions and should be excluded from evidence. First, because of Mr. Selder's heritage, the confessions are a result of his cultural background by constantly agreeing to whatever is put forward to him, even if he doesn't understand. The cogency is significantly affected because a reasonable person, without the knowledge, would assume that the confessions are reliable. Secondly, if it weren't for the police officer's improper conduct, Mr. Selders may have not confessed to anything. Mr. Selders was induced by police officers and Wendy to confess because Mr. Selders was not properly informed of his free choice to remain silent. The involuntary police interview combined with Mr. Selders' cultural background make for two strong grounds for exclusion as the discretions overlap and the evidence would not have been present if the police were to follow public policy. May it please the court. That concludes my submissions.